The Premack Virtual Online Law Office presents attorney Paul Premack with this week's legal column, published in the San Antonio Express News on mysa.com and on our website at www.premack.com. This week's topic: does a ladybird deed trump instructions in the will? Dear Mr. Premack, my mom and dad had a will that left their assets to me, my brother, and my sister. Years later, they signed a ladybird deed leaving their home to me and my sister only. It's filed with the courthouse. My brother has gotten his inheritance money and lived for free in their garage apartment for over 6 years. They paid his bill, giving up their supplement insurance and nearly their medications to care for him. He did not want his name on the ladybird deed because of his felonies and the fact he has never paid taxes, so the IRS would come after his part. He has no part as far as I'm concerned. His part was given to him while they were living. Does the ladybird deed disqualify the will? Signed, S.T. The phrase ladybird deed is an informal designation that's starting to be thrown around rather loosely. To be specific, it is a legal transfer of title in which the property owners transfer title to the house while retaining 2 rights. 1, the right to occupy the house via life estate, and 2, the right to unilaterally change their minds and reclaim or sell full ownership of the house. Ladybird deeds are also referred to as enhanced life estate deeds because an ordinary life estate deed does not include the right to reclaim ownership. Ladybird deeds are most often used under current Texas legal rules to help avoid a claim from the Medicaid estate recovery program. In addition to being different from ordinary life estate deeds, ladybird deeds are different from regular warranty deeds. A warranty deed is a full conveyance of ownership that does not include either of the reserved rights, no right to reclaim title and no right to occupy the house via life estate. Since you said your mother signed a ladybird deed, I'll assume you're correct, but you should reread the deed to be sure that you're calling it by the right name, and that it is not an ordinary life estate or a full warranty deed. You also said your parents had, quote, a will that left their assets to me, my brother, and my sister, close quote. Are you forgetting to mention that they first left their assets to each other? When your father died, the will probably left his share of the house to your mother. The children have no rights until both parents die. That would be consistent with the ladybird deed, in which they retained life estate until both of them die. In the ladybird deed, they named only you and your sister as owners of the house, and left out your brother. You are concerned because the deed is not consistent with the will. You wonder which dominates, the will or the deed. The answer is, the deed dominates over the will on condition that your mother does not exercise her retained right to reclaim ownership. If she leaves the situation as is, then when she dies, you and your sister become full owners of the house by virtue of the ladybird deed. Title passes to you without probate and without reference to the will. Your brother gets no part of the house. However, if she exercises her retained right to reclaim ownership of the house, or your brother convinces her to exercise it, then the ladybird deed is canceled. Once canceled, the will is restored to its primary role as the legal tool for determining ownership of the house. If the deed is canceled before your mother dies, then your brother does inherit a 1/3 share of the house under the terms of the will.